thanks for joining us this morning. Yeah, just to reiterate, my name is Richard Hewitt. I'm a partner in the employment team at VWV. I'm joined by my colleague Alice Reeve today, who's also a partner in the employment team, and we advise on the full range of employment law issues, including grievances that are raised by employees with their employers, and it's something I think that we're perhaps seeing a bit of an increase of in the last couple of years. Today we are going to look at 6 of the more tricky issues associated with grievances. So not necessarily the basics of how you address a grievance, and we'll assume you're all familiar with the basics of a grievance process and what a grievance looks like. But what we will be addressing are the 6 points set out on the slide here. So how do you address grievances that are raised during other formal procedures? Handling grievances when a key party is off sick, managing complaints involving senior leadership. So I'm going to look at those 3, and now Alice is going to look at the remaining 3, so investigating overlapping or repeated grievances, dealing with reluctant witnesses, and then rebuilding the working relationship after a grievance outcome. So without delay, I will move on to look at grievances that are raised during other formal processes. Now, I think it's something that is fairly commonly arises when a formal disciplinary or performance process is underway. And perhaps before you think about the challenges and how you're going to address this, the first question to ask is, has a grievance actually been raised? If we look at the ACAS Code of Practice on discipline and grievances, that states that a grievance concerns problems or complaints that employees raise with their employers. So a pretty broad definition there, and a complaint raised by an individual during a formal process may well amount to a grievance. So I think it's important to think about it from that perspective, but also then consider what's the specific nature of the issue that's being raised. It could be, and often is, a representation that the individual is making that's to be determined as part of the disciplinary or performance process. It might relate to a point of process, it might be a ground of defence, it might be a point of mitigation, and so not necessarily a grievance that falls to be determined under a grievance process. Or does it relate to something more fundamental? So, for example, the conduct of someone involved in that process, or is it something that's entirely unrelated to the ongoing process? All of that analysis is going to affect how you look at the grievance, if one has been raised. Secondly, is the employee asking for something to be treated as a grievance? I think if not, then it probably makes sense to approach it as part of the other ongoing process. But if they have raised complaints and you are going to approach it in that way, then be open with the employer, let them know that's how you're going to deal with the issue that they have raised. That then allows them to consider whether that's acceptable or to ask for it to be treated separately as a grievance. However, going back to that broad definition of a grievance set out in the ACAS code, it may be best to treat issues raised by employees during these processes as separate grievances. So if a grievance is raised, how do you approach it fairly, whilst also still carrying on with a fair disciplinary process or a fair performance process? I think it can be perhaps more difficult during disciplinary processes, which are often more time pressured than performance processes, especially where the alleged misconduct is serious, perhaps a party's been suspended. So a grievance being raised at that point can present genuine difficulties as to how you follow that process fairly. Next point to consider is whether the disciplinary or performance action should continue whilst the grievance after the grievance has been raised. If that process does continue, then you may have complaints from the employee saying there's been a failure to address the grievance first. That amounts to unfair treatment, for example, giving rise to arguments that the outcome of the disciplinary process or the performance process had been predetermined by not pausing to consider the grievance first. The type of argument that's raised is that it didn't matter what I said, the outcome was always going to be the outcome. So do bear that in mind. Then moving on to delay. Grievances are often or can be raised as delaying tactics in formal processes, as a means of potentially in the mind of the employee, postponing the process entirely, or certainly delaying it, or delaying the imposition of any formal action that may follow. And you may well consider that the grievance raised has been a delaying tactic, and it may well be, but it's difficult to say that to a member of staff whilst still acting fairly. And even if it has been raised as a delaying tactic, you're probably best off considering the grievance either separately or as part of the ongoing process, in order to act in a reasonable manner. And then finally, looking at legal risks here. So mishandling of overlapping processes can lead to claims of procedural unfairness in one or both, can lead to claims, constructive dismissal claims, for example, if not managed correctly. So do be aware of that. A failure to deal with a grievance fairly can result in a breach of the ACAS code of practice. That can lead to an uplift of compensation up to 25%, if there's a future unfair dismissal claim, which is successful. And also, just not dealing with the grievance properly during another process can make it harder to complete the disciplinary or performance process and work together in future. So how best to address these issues when they arise? What strategies are there to consider? So firstly, for me, assess the grievance's relevance. So does it directly impact on the ongoing disciplinary or performance process? So what's it about? And how would you address it? The two options are stop the existing process and deal with the grievance first, or deal with them concurrently. Both are provided for in paragraph 46 of the ACAS Code of Practice on discipline and grievances. So both options are open to you. If the grievance relates to the substance of the formal process that's ongoing, I think sometimes there's no need to pause that formal process. You've got to remember these processes must be substantively and procedurally fair. So issues raised about an employee that relate to either of those, I think, can arguably and fairly be dealt with as part of that ongoing process. And I'd say the majority of cases that tend to arise in this respect, that's what the grievance is about. In terms of running a concurrent process, what does that allow you to do? Well, it allows you to effectively deal with the issues at the same time. The question is then whether is that going to be a separate and parallel process, or is that going to be something that you factor into the ongoing formal process? If it's a separate grievance process, then I think ideally you want to conclude that grievance before you move on to a formal disciplinary hearing or a formal performance management hearing, if the grievance affects how that process is operating. Examples in this respect are where the employee believes the investigator is looking at other conduct issues, perhaps outside of the original complaint or the original terms of reference. For me, those sorts of issues can be dealt with as part of a disciplinary process, because they relate to the procedural fairness of the investigation that's being undertaken. But perhaps where we've got a complaint that the investigator has behaved unprofessionally towards the employee, it may be sensible to pause the formal disciplinary or performance process and address the grievance before returning to conclude those processes. Certainly done plenty where the grievance is combined into a disciplinary process. You have the same investigator, you have one panel that hears and determines the grievance before moving on to the disciplinary aspect of the hearing. And I always think there's a risk of procedural unfairness with that approach, and certainly it's unpopular with employees and trade union representatives, but it can be done where the grievance relates to the process or the substantive elements of the disciplinary. And as I said, often where there's greater time pressure in disciplinary processes, this is the way that an employer prefers to deal with it, so as to avoid unnecessary delay. Where you've got concurrent processes running, or where it's being dealt with as part of the other formal process, important to keep detailed records of both, records of rationale for acting in a particular way, records of your communications with employees as to why you're dealing with something in a particular way. And I always think a separate grievance decision, a separate disciplinary or performance outcome, and separate rights of appeal in both are important. And then returning to the issue of claims where you have these sort of concurrent issues arising, I always think you'd have to deal with a grievance procedure particularly badly for it to amount to conduct that was intended or likely to amount to a fundamental breach of contract, thereby giving rise to a potential constructive dismissal claim. So I think provided you act reasonably and you communicate in a reasonable manner, you should be able to deal with these issues without necessarily giving an employee a constructive dismissal claim. Okay, moving on to when a key party goes off sick. Again, something that commonly arises, and I think there's always going to be some delay when this happens, even if that's just for you to stop and assess how to approach the impact of sickness absence on the ongoing grievance process. So yeah, as you can see from the slide there, that the key issues being delays and the impact on the investigation, whether it prevents you having access to critical information, and whether we've got underlying disability discrimination issues to consider. I always think where we've got sickness issues affecting the progress of a grievance, well, the aim has to be not to let that materially affect how the investigation is undertaken and how the grievance is to be determined. You know, what's your duty in that respect? Well, it's to carry out a fair and reasonable investigation without unnecessary delay. So whilst there may be some delay when a party goes off sick, you've clearly got a good reason for that delay. But it's important to try and keep the process moving. A case of balancing how you deal fairly with someone's sickness absence whilst still maintaining the integrity of the grievance process are the key issues to consider. And then where we have got a potential disability, I think perhaps a greater degree of caution is needed. We may be looking at medical assessments and considering reasonable adjustments in order to progress with the grievance and deal with the employee's ill health. So in terms of sort of best practice suggestions for dealing with these types of issues. So firstly, I think assessing reasonable adjustments or adjustments to the process to facilitate the participation of the person who is unwell and off work is key. So I think communications to say to that individual who's off sick that essentially they don't have to participate in person, and that there are alternatives to doing so, and to put those forward. So as the slide sets out there, virtual interviews, written statements, perhaps instructing a companion to attend and deliver their statement on their behalf are all common and very, very reasonable alternatives to offer when this issue arises. What you're doing is emphasising the importance of participation of the individual, recognising the sickness absence, but giving the message that the absence does not ultimately stop the process. It may be that, as I mentioned just now, asking them to attend an occupational health assessment is needed, and I certainly think that can be a very powerful tool when dealing with these issues. Firstly, your contract may give you the power to require that person to attend an occupational health assessment, which can be useful if you've got someone who's reluctant to do so. But then it's also an opportunity for you to put particular questions to the occupational health assessor, essentially asking, can this person participate in the grievance process, but for their ill health? Can they participate in person, or can they participate in one of a number of alternative ways that doesn't require them to participate in person? From my experience, occupational health are normally likely to say yes, that individual can participate in some way. We often find as well that dealing with the issue at hand can often help with the cause of the ill health. For example, the ill health is caused by the stress that's related to the issue that is the subject of the grievance, or a stress caused by their involvement in the grievance process itself. And often occupational health will say, well, the best way of dealing with that ill health is to engage with the issues at hand and to work through the process and to resolve that as far as possible. Also consider, are there alternative sources of information that you can utilize to gain the same information? So gathering documentary evidence, speaking to other people who may be able to provide the same or similar information. Essentially, though, you should be doing that anyway. That's likely to form part of a thorough and reasonable investigation in any event, but it becomes equally important when you've got a key individual missing due to ill health. What about delay and interim measures? So if delay is unavoidable due to ill health, are there any measures that you can put in place to temporarily manage workplace dynamics, or mitigate the risk? And the suggestion is, temporarily adjusting reporting lines or working arrangements to maintain some stability. Now, I think whether that's possible or not is going to depend on your individual workplace, and I think in practice this can be quite difficult, particularly if the complainant and the subject of the grievance work together on a day-to-day basis. But it's still important to consider what can be done and to offer some alternatives if there is going to be delay as a result of a key party going off sick. The longer the delay as well, we often find that creates a greater chance of further issues arising. So other staff can be affected, the mood in a team or a department worsens. We get complaints from other people, we get complaints from the party who's not off sick as to why this is taking so long to conclude. More correspondence is generated and the whole issue becomes slightly more complex and harder work to manage. Although I would say is if it's the complainant or the subject of the grievance who's absent, at least for that period, they're not in direct contact, which may alleviate some of the pressures that have caused the grievance in the first place. And then communication. So keeping the absent party informed about the status of the investigation, keeping other parties informed about the present position as well. If there's going to be some delay, then I think it's important to be upfront about that, to the delay, and to explain as far as you can, respecting data rights, as to the reason for that delay. Always important to stay in contact with individuals who are absent, and others is often a source of further complaint, i.e. no one was in touch to update me on the present position, no one was in touch to check on my welfare. So yeah, open and transparent communication with all parties where we've got delay through ill health during the grievance process is important. I think it also creates a paper trail to show that you're actively and reasonably trying to manage the grievance process. Okay, moving on to my third and final issue. So managing complaints that involve senior leadership. So what are the key challenges? So the power dynamics and the perception of bias. So perhaps a feeling amongst staff, is there a feeling amongst staff that there's no point in bringing agreements against senior leaders because we know it's not going to be upheld because they hold all the power, which can of course affect culture within the workplace more broadly. Maintaining confidentiality and trust. Yes, potentially grievances, conflicts involving senior leaders can be more visible, but I think that also depends on what's the nature of the grievance. If it involves the behaviour of senior leaders, then it may well be known within the organisation. It may have been witnessed by staff. If it relates to an individual and perhaps more private process and a more or less senior member of staff, then perhaps it's not quite so well known. But whatever the nature of the grievance, it's really important to maintain confidentiality throughout that process as far as possible, including giving thought to who has to be involved in the investigation, who has to be spoken to, and the best order of doing these things to really limit the circle of who knows to those key personnel, really. I think communication with all staff, including senior leaders, is important, as is the professionalism of those involved. So important for senior leaders to understand and accept that sometimes they might be the subject of a grievance, as can be the case with all staff, and that they should let the process be followed and run its course, and have some faith in that process. So that's an example of that we dealt with relatively recently. It was a grievance regarding a decision over an appointment, an internal appointment to a role. The internal candidate who was unsuccessful was unhappy with that process and the decision making, and alleged bias and unfairness and discrimination. We knew it had been talked about amongst staff at less senior levels, so confidentiality issues had arisen from the outset. But I think it's saying a case of, well, we will deal with this process confidentially, and we want everyone involved in the process to respect confidentiality as well. Perhaps the other key point to note when we've got grievances about senior leaders is that they just can't be ignored. We need to show there's transparency in the approach to addressing with them, and that there's a sort of nothing to hide culture within your organisation. And then managing that risk of retaliation and claims. Staff may be concerned about raising grievances against senior leaders because of a perceived fear of some retaliation in future. For me, again, it comes down to culture, to communication, to your policies and procedures, encouraging and empowering staff to raise issues if they do have them to raise. And also, I think making it clear to staff and to senior leaders that all sorts of claims could arise out of retaliatory behaviour, constructive dismissal claims, victimisation, discrimination, harassment, whistleblowing. All of those have an impact on the individual, they have an impact on workplace culture, and they have an impact on the reputation of the organisation. So I think key messages that any retaliation following a grievance will not be tolerated are absolutely key. And then moving on to how you might address those issues where grievances are raised against senior leaders. I think the first point comes down to carrying out an appropriate investigation. So really, what's the issue that's facing you at the outset? Is there someone senior enough and independent enough to be able to investigate and reach a decision on the matter where it involves a senior leader in the organisation? And you may reach the view that there's not, and it may be best to use an external investigator to carry out that process. We certainly used our colleagues at Narrow Key HR in that capacity where we've been faced with grievances against senior leaders in an organisation, because it just allows them to go in and carry out an investigation without any agenda or any perceived agenda, and to do that independently and impassionately, and then to present their sort of findings to a member of staff to then take that decision, which leads me on to the next point. If you are going to outsource your investigation, which you're permitted to do, it's important that you try as far as possible to retain your decision-making power in-house. So in this case, you'd have a sort of separate investigation and decision-making roles. You may need someone at board level to be able to act in that capacity. Otherwise, use the most senior person available. As I said, there's no requirement to outsource any elements of the grievance process. You're just looking at conducting a fair process in all the circumstances. And if you don't have the size and the resources for independent people to carry out those roles, then you have to make do with what you can. Where we've got senior staff involved, think about who's going to play what role in that from an early process, early point, who will investigate, and who would be available to hear an appeal. Again, something that might need to be considered at board level. Then looking at transparent communications. Now, you may be departing from your written grievance process when you're dealing with complaints against senior leaders, particularly if you're thinking about engaging an external investigator and then having a separate person to take a decision on that grievance. So firstly, check you can do this, check your grievance procedure is not contractual, ideally it's not, and then explain to the person who's raised the grievance what you're proposing to do and why. Ask them for any comments on that process and take them into account if they are reasonable and it's sensible to do so. And I think reinforcing in any communication that goes out in these matters that both the complainant and the subject of the grievance will both get their chance to fully explain their respective positions. And then we mentioned there at the bottom, consistent accountability. So applying findings and recommendations across all levels to demonstrate that grievances are handled impartially. I mean, yes, that absolutely sensible. Where you can do that, again, I think it depends on what the grievance is about and whether it's been upheld. But nonetheless, you may find that even if a grievance is not upheld, there can be lessons can be learned which can inform changes to future culture, procedure, and practice that are worth implementing. What I'll also say as well is that unless the grievance is sort of upheld fully, then the complainant is often unhappy, and perhaps asking what they hope to achieve at an early stage in the process could be a way to manage expectations and arrive at an outcome that's acceptable to them and to all. In any event, senior leaders and the complainant will have to, or are likely to have to, work together in future after a grievance, and therefore it is sensible to look at ways of decreasing the risk of the same or similar issues arising again, so that they can work together in future. Which is analysis is going to look at that type of thing in more detail shortly. Okay, well, that brings me to the end of my 3 issues, and I will hand over to Alice to continue.
Great, thanks, Rich. So our fourth of our tricky issues that arise is where you have overlapping or repeated complaints, and these can probably arise in 2 situations. One where one individual raises a concern and then the other person brings a counter grievance. We see that all the time, and that's going to be familiar to you. Or where somebody raises one lot of issues, and then before you've had a chance to reach a conclusion, they raise another lot of issues, and sometimes another lot of issues, and you can never quite get ahead of that, where we've got overlapping or repeated grievances. And both of those situations can create significant risk. I mean, first and foremost, around demonstrating that we've adequately addressed each and every one of those grievances that have been raised, and we've dealt with that properly and reached an outcome. And obviously, if you haven't been able to do that or demonstrate that, one, it can lead to individuals feeling that they don't have faith in the process, and potentially bringing a claim. And if you can't demonstrate that you've dealt with that particular complaint and it's gone properly through all the stages of the ACAS process, obviously that could be an uplift in relation to that claim as well. I think probably on the ground, the biggest risk out of these situations where you have ballooning grievances is around the resource that it takes. And we all know quite how difficult it is to manage a single standalone grievance when they are then developing into counter grievances or repeated grievances. It really can strain resources, and actually then it becomes protracted. And I think, again, we all know that where things are not dealt with quickly and promptly and effectively, that leads to parties becoming entrenched, drags more people into it, and all of those bring organisational risk as well, both in terms of the grievance process, but other things that you should be doing instead of dealing with workplace complaints. So what are the best practice tips, or how might you deal with some of these challenges, which we've got on the next slide? Well, just to pick up the sort of counter grievance point first, which I think is more straightforward, that where you've got an individual who raises a grievance and then somebody is unhappy and raises a counter grievance, there are a couple of ways in which you need to do that. Firstly, it's essential that you do address both issues. It may be that you can reassure the person who's raised the counter grievance that actually, where the issues entirely overlap and they're really their defence or response to the complaints that have been made against them, the best thing to do is to deal with that all within one process, and reassure them that they'll have every opportunity to respond. And so to try and avoid the second grievance process being engaged. If that isn't possible, then you obviously need to give both of them ownership of their own grievance processes, but you may well be able to deal with it all within one investigation, because the facts are so intertwined, if that is the case. And so you'll minimise the meetings and the witnesses, but you will then obviously need to have 2 separate grievance reports essentially written up, and both individuals who have raised grievances will have ownership of their process and understand whether their complaints have been upheld or not, and be able to appeal those outcomes if they are minded to do that. I think our advice generally in relation to all of these issues is, where possible, try and minimise the number of processes and the spin-off investigations as far as possible. If we look now a bit more about where you've got an individual who's raising overlapping or repeated grievances, we quite often hear they raise one grievance and then they say they raise a second one. We quite often hear clients saying, well, hold on, this wasn't part of the original complaint. Let's compartmentalize it. We'll deal with one, then we'll move on to another. I think you need to pause and reflect and think, well, what are we ultimately trying to achieve here? We want to understand somebody's complaints. We want to determine them, find whether they're well found, and we want to resolve them. We want to draw a line and we want to move on as quickly as possible. So it is going to be the case that in most instances, it is going to be better, if you can, to combine them into a single grievance process, simply to avoid duplication and have a more streamlined and consistent approach in relation to that. Sometimes that isn't feasible, and you will more likely need to deal with them both separately, but it may be possible that you can pause and deal with the two separate grievances, but then you pick them up and hear all of the outstanding complaints within one appeal process in order to streamline it. I see people have got questions. I think if possible, we'll finish the content and then we'll cover off all the questions at the end, so put them in the Q&A box if that's okay. If you've got tech issues, put them in the chat and Ellie will help you with that as well. In terms of management of risk, you obviously need to ensure that you have dealt with all the grievances. So actually keeping a clear record and audit trail of the grievances that have been raised. We've all seen those really long letters. You might have one really long letter and then a second and maybe even a third with some duplication, very difficult to unpick. What you need to do at a really early stage is, in the relation to the first one, identify what are the specific complaints. Can we agree those with the individual? Can we document those as well? Can we raise them? Make sure we've agreed those with them. Then if they raise another or subsequent grievance, actually then we can map across what are the issues that they have raised now. Are they the same as the ones we've already captured? Are they different? So then you've got a clear document with the grievances in the first one, the grievances in the second one, and combine them where that's appropriate. You clearly don't want different outcomes in relation to the same grievance, which is why ideally you've got to make sure you've got some method of considering every grievance that they've raised, but not considering the same thing twice, and being really robust about that too, and being able to keep a handle on it to show that you've done that. I think the critical thing as well is that sometimes people raise grievances or subsequent grievances if they feel that they're not being fairly treated or they don't understand the process that's being followed. That's the same with counter grievances as well. We all know how long these things can take, but the importance of making sure that you are keeping someone up to date, both parties, if there are more than one, so that they know exactly what's happening and what the next steps are and what the status of the position is, will hopefully minimise or avoid this sort of spin-off grievances that can be so difficult to manage on the ground as well. The next tricky issue that we thought we would look at is one you will all be familiar with, which is how to deal with reluctant witnesses. And so if an individual brings a complaint, obviously sometimes they're reluctant to bring the complaint in the first instance, but that's not really what we're talking about here. We're talking about where they say this incident was witnessed by other people and you should speak to them. Or if in the case of bullying or some of the allegations of bullying or some other similar behaviour, they say you should speak to these witnesses because they've been subject to the same behaviour or they feel the same way. So you have got witnesses who are particularly potentially pertinent to the issues to be determined. And then those individuals essentially say, I don't want to participate, I want to keep my head down. That creates a number of risks. I mean, first and foremost, the whole point of grievances is someone can raise a concern, you can look into it, you can gather the facts, and you can make an informed decision about the outcome and the appropriate steps that are necessary as a result of that. So if you don't have all the relevant witness evidence, all the relevant facts at your disposal when you're making that decision, it may undermine the decision itself, which obviously potentially means that they may challenge that it's unfair, but also means that as an organisation, you're not necessarily getting to the very best outcomes as a result of grievances raised. Obviously, that in itself can also bring risks that individuals will say this hasn't been a fair and lawful process, and you have a duty to not carry out a comprehensive investigation, but to carry out a reasonable investigation in the circumstances and gather all relevant information, both for and against the grievance itself. And so if they've said you should speak to all these people, and then you haven't done that, you can see that they may feel that that gives them grounds to disagree with the ultimate outcome, particularly if it doesn't go in their favour, and argue that you haven't undertaken a sufficiently reasonable investigation into the issues that they have raised. Now, the main reason that individuals don't want to become witnesses is because they're worried about reprisals generally. They are all working together, and we're going to touch on that shortly, but everybody is working together and they're worried about future repercussions, particularly, but not always, if it's either a colleague or if it's somebody who is more senior. So those difficult complaints that Rich talked about, where they're against senior managers, individuals have a real fear of reprisals or retaliation as a result of participating in a grievance process. So recognising that we really want individuals to participate and that we really want to be able to gather all the potentially relevant evidence, how do we deal with this? So if you can flick on, Rich, onto the next slide. Well, I think it is important that you have a culture that individuals understand that if they've got concerns, grievances can be raised, and there's an appropriate process in order to look into that. And actually, if you're an employee, I think you do have a duty to participate if you are a witness to something. And I think HR can play a role in explaining that to individuals, and that it is part of being a professional colleague in a workplace that you will participate in employment processes where you need to do so. But actually then it's about reassuring those people as far as possible. We will all have heard the "can I be anonymous?" It's a really difficult question and really difficult to guarantee. I mean, case law does provide some situations where anonymity is an appropriate thing. You would always listen to the reasons why someone wants to be anonymous, and you will consider, well, can we still appropriately gather the facts and make sure, put the issues to individuals, or determine the issues if we know the facts of what happened, we've got their evidence, but we don't necessarily attribute it to a particular person. Can they remain anonymous? But in most workplaces and in most situations, it's pretty impossible to effectively deal with something and guarantee someone's anonymity. It's absolutely obvious who the individuals will be because of the incidents that you're looking into, their role in it, their response into it. So in most cases, it's going to be very difficult to undertake an effective and fair process and retain anonymity. So the focus really in cases should be about reassuring them about the support that's offered. So there'll be a couple of types of support. I mean, you may well have employee assistance lines where if they can just talk to or explain their concerns about that, you may nominate a colleague in HR or someone else who they can talk to about the process itself or raise concerns. And you should absolutely make it clear that they will be protected from any adverse repercussions. And that is really serious. And in fact, both the person who's perhaps complained about as well as witnesses can be told of the importance that everybody is expected to participate. And as long as they are giving their version of events honestly and factually, and in an appropriate way, there won't be any reprisals as a result of that. And if there are, they need to know who they can raise that with, a senior person, and actions need to be taken to address that effectively as well. If you do have a culture where, there are subsequent issues where individuals are not given access to training, not given access to promotions, not given pay rises, or they're subject suddenly to performance capability processes and things like that, you should be able to spot that. And it's really important that you address those things so you can really show that there's a culture where there are no reprisals as a result of acting as a witness or raising a grievance in the first place as well. And then finally, again, sorry to bang on about documentation, but actually, if you're thinking about, we need to demonstrate that we have undertaken a reasonable investigation, you should document all the witnesses that were named as potential witnesses, those that have been spoken to. If you think some aren't relevant, you can document the rationale for that. But if you think there are potentially relevant witnesses, but they have refused, you should demonstrate that you've spoken to them. You should also absolutely demonstrate the efforts you've made to try and reassure them, try and encourage them to participate in the investigation, so that then if the individual who raised the grievance or ultimately an employment tribunal is looking at whether the investigation was reasonable, you can say, look, it was as fair as it could be in all the circumstances. We did our best efforts to encourage these individuals to participate, and then we ultimately had to proceed and make a decision based on the information that we had available to us. And finally, before we get on to all the questions, we wanted to just look at the aftermath of a grievance, and Rich touched on this as well. We all know that although ideally, someone can raise a grievance, you would get to a good outcome, and then you would look at how it can be resolved. The fact is that raising grievances amongst colleagues can leave lingering tension, mistrust between individuals, can impact morale. And it can be really difficult, and it can also then spin off to further complaints because people feel defensive, so sometimes they react badly to things and put in further complaints, or there's just a lack of harmony in the teams, which impact on efficiencies and good workplace relationships as well. It can be really difficult to maintain objectivity and support both individuals, and it's really important that actually, even if a grievance was upheld, the person who the grievance was about needs to be supported as well. And so what are the different ways in which you might address some of these issues? Well, I think, actually when a grievance is about you or about a senior person, it's a really difficult thing. Everybody needs to recognise that and acknowledge that. It does become part of being a senior person, a manager, that at times you may have complaints levied against you, whether they're well-founded or not. And I think as an organisation, it's really important that you make sure that your managers are aware that individuals may raise complaints, that they're perfectly justified in doing that. And whether they're well-founded or whether they're not well-founded, it is their right to do that. And it is important to be broad-shouldered and take that on, and not then feel that you want to be too defensive, raise those counter grievances, or it spins out in terms of repercussions in terms of how those managers behave after the event. So I think support for managers, but setting those expectations is really important as well, and explaining that it becomes part of the role. But if we have got difficulties, or we've got two colleagues, I think some sort of facilitated discussion. I think often individuals in grievances, often it's a lot of documentation. They don't usually meet each other in a grievance process. People become very fixed on their ideas and actually their perspective of events, and actually having some sort of dialogue to be clear that there is another perspective, that wasn't the intention, that fundamentally people are human and things weren't meant, is a really effective way of just dissipating tensions, really. So that could be through HR. It could be that individuals encouraged to speak to each other directly, going out for a cup of coffee, or just sitting down and just rebuilding those bridges, or potentially you use workplace mediation as well to help get over that. And actually, even if a grievance has been upheld against somebody, that ability to sort of recognise that and both move forward, that's when you might find a mediator particularly helpful. I think where there's been a particularly bloody grievance and it's really difficult, having a clear action plan, and as HR owning that, to check in with both parties potentially and all witnesses to see how things are going and look at taking some active steps to make sure that relationships are improving and things are settling down is a useful thing. Having said that, time does ease. So actually, it's about checking in, about making sure everybody's got the support that they need, not just leaving it, but do give it some time and for the dust to settle as well, and for people to just move on, because that does happen. And I think finally, it's about promoting that culture where everybody understands that things may not always go as well as you would like. Sometimes issues do arise, but actually everybody does need to be professional and act in that way. And you may not be best friends with the people that you work with, you may not like them, but actually you can be professional and respectful, and that's an important part of working together effectively, and need to move forward. As Rich said at the beginning, we are seeing more and more grievances being raised. I think someone mentioned in the chat, and we'll pick these up, that ideally you want a culture where individuals can raise things directly with people, things are nipped in the bud. There is no doubt that catching things at the earliest possible stage is the best way forward. So individuals should be encouraged to do that, speak directly when there are issues, but you should get managers as well who are willing to support and just tackle issues at the lowest possible level to nip them in the bud. But you then also do need to understand that if individuals raise formal grievances, that's their right to do that. And you want to ensure that there is an effective process that complies with your own policies, but is legal as well, but really gets to an outcome where you find whether the grievance has been upheld or not, and clearly helps resolve things, and everybody moves forward, and there is a culture where there are no reprisals as a result. And if you can achieve the balance of that, that things are dealt with at a low-key level, but where there are grievances, they're dealt with properly and people move on effectively. That is the best hope for good workplace relations. We do recognise that it's difficult, and obviously we've picked up quite a lot of the things that cause particular tensions when dealing with these things. Richard had gone on to a slide to say we do have some training for managers on many employment things, but including how to deal with grievances as well. So if that's of interest, Ellie's about to launch a poll, so please just do let us know. That's some e-learning, but obviously both ourselves but also our colleagues in Narrow Key can do in-person training for managers as well about investigations or how to manage grievance processes or dealing with the fallout. And we've then got, I think, about 10 minutes for questions. So I'll have a little look in the Q&A box. Yeah, so the first question absolutely is about any advice on ways to deal with complaints if possible, before dealing with it formally. We do offer mediation, and we think our managers need upskilling to manage situations because there's a culture of raising grievances. Yeah, exactly. That's that's absolutely hits the nail on the head. I think ideally, yeah, you do want people to be able to raise things informally, and I think that is about leading by example and encouraging individuals to do that directly. It may be some training for everybody about how best to interact in the workplace, but definitely the upskilling managers to, you know, tackle things, to have those difficult conversations. I mean, I think often it's that actually, can we address the elephant in the room? Can we sit down? Can we sort this out? Because, you know, you want to get that perfect balance, really, by which ideally things are resolved without formal process, but then you do engage formal processes where there is no other option, where things are serious or where they're complex, or whether they haven't been resolved through the informal stages. And we've definitely seen organisations falling into both camps, where they don't, you know, follow enough grievance processes and direct that, and so you've got lots of issues that never reach a conclusion, a line isn't drawn and resolved. And we've seen others where there's hundreds of grievance processes all going on through formal processes at the same time, and that's equally harmful to the organisation as well. In terms of how to deal with that, I think that is I think probably focusing on how to have, you know, address issues and have those difficult conversations and encourage people to raise things, you know, informally with drop-ins, or potentially, you know, at other times throughout the year is a useful thing. Oh, Rich, I don't know if you want to pick up the next one.
Yeah.
It's now, is there a way to identify vexatious or malicious grievances?
Yeah, I'm not sure that I'm not sure necessarily it is without giving the impression that you don't want to follow a fair grievance process. I mean, I think we've all come across those where we consider them to be vexatious or malicious, but often I think it's a case of going through the process, the investigation process, allowing the employee to put their case and others to respond, and then reaching a decision. And maybe that then once that process is concluded, we're so clear that it was a vexatious or malicious grievance that then you do want to take action against that individual for
You're right. It happens
the
really
way they're
rarely that a
acting.
grievance is properly vexatious or malicious, doesn't it?
Mm,
Really? I mean, I
mm,
can hardly think of any that I have seen in that way. And you're right, it's almost impossible to determine it until you've actually established the facts.
mm,
I think the other thing we see is that people feel that somebody is malicious or vexatious because they've raised repeated grievances, which is obviously the sort of scenario that I described. And actually the guidance, there is some guidance around sort of complaint
mm,
handling, which makes it clear that that isn't the case. Actually, it can never be the person who's vexatious or
mm,
malicious by raising lots of complaints. It has to be the complaint itself. So actually, there could well be 30 valid complaints. That being said, and you need to look into each and every one. That being said, if you have got somebody who's raising lots and lots of repeated grievances in the workplace, you may well intervene and look at, is there a breakdown of relationships, or is there some other way to manage this?
mm. I think as well, it's quite often an indication that there is a breakdown in the working
Yeah.
relationship anyway. So it might be coming to an end, and therefore you're probably better advised to be to really be transparent and fair about investigating that process and then reaching your conclusion. Because if employment's going to end, at least you can show, well, we dealt with that grievance even though we suspected it to be malicious or vexatious.
Yeah, I agree. We've got a couple about reluctant witnesses. So actually there's one that's specific to school environment, which I know many of you are, and both Rich and I obviously work with lots of schools. If witnesses are students, can we protect and support them, and can they be anonymous? Well, Rich, I would say that although I was talking about anonymity, that was largely about adults who were also employees in the workplace. And generally where it's school witnesses and they're under 18, you would give them anonymity as long as the individual who's subject to the complaint can understand what that complaint is and how they, in order that they've got sufficient detail in order to respond to that. We sometimes get adults saying, well, I need to know who the complaint's about, or who the witnesses are, so that I can see whether they might have colluded or there might be something to suggest that their evidence can't be trusted. But actually, I think you can be quite robust about that and say, well, do you think there's anything that might have caused that situation? Are there any reasonable grounds to do that, rather than doing it? So in most cases, I think you would have anonymity amongst the students. Rich, I don't know if you've got any other comments about that.
No, I agree. I think it's ideally try and leave students out of this process
Yeah.
as far as possible. But no, I agree. I think anonymity might be appropriate, but it really does come down to, can the individual answer the case, the subject of the grievance respond to that case that's against them without knowing the identity of witnesses. So a
Yeah.
case by case basis, to be honest.
And the next question is about when witnesses say, how will they be protected if they need to be named in an investigation report? What are the different tips and things that we can do, and how do you risk assess that, particularly if they're worried about bullying? I mean, these are the most difficult ones, but I think you do absolutely need to encourage people to say that actually if the organisation needs to address something, you absolutely need witnesses to step up and stand by their witness statements. And I think that power of having to explain that to them is really useful and really important. Obviously, if it leads to an exit, that's less of an issue, but you can absolutely see that if that leads to some form of sanction, written warning or a final written warning, that they may be worried about their ongoing relationships. But actually, I think you do need to be really clear that that will be absolutely addressed with the person who is alleged of bullying, and that if there is any subsequent or repeated behaviour, or any suggestion that because they've been a witness, they've been subject to reprisals, that is really, really serious and probably gross misconduct. as well. I think sometimes we see that it's helpful for a senior person in the organisation to give that message rather than perhaps the investigating officer. I mean, it depends, but so that it's taken seriously. Rich, I don't know if you've got any other ideas. It is difficult, isn't it?
Yeah, I'm sorry, I've lost the question. Sorry, question's gone off the
Oh, that's
screen.
all right, don't worry. And so then can I ask you the next one? A person raised a bullying grievance which wasn't upheld. And there were actions to get the relationship back on track. And I think that's a really interesting point in itself, that you might find the grievance is not upheld, but you can still have recommendations or things to look at to try and improve working relationships or address the issues that have been highlighted. But in this case, in the question, the complainant, the person who's raised the issue, refuses to engage and won't speak to managers. We've offered lots of ways of doing that, but they won't budge. What next? Oh, you might need to get more detailed legal advice. I mean, that's interesting. If someone raised a grievance, the fact that it wasn't upheld, they will find that difficult. Rich, it's hard to think of any tips other than saying, well, they need to get on with their they need to get on with their job.
Yeah. Well, it does look like, as Amy, the pretty sensible conclusions from that grievance, and then offering ways to get the working relationship going. So to doing as much as looks reasonable, if not more, from the employer's perspective. But I suppose if we've got a member of staff who is refusing to engage, and that's causing problems in the working relationship, and therefore they're failing to follow lawful and reasonable management instructions, then it feels a bit like we're going down a conduct process with that individual.
I've just seen there's loads of questions. We better pick up our pace. Sorry, that's my fault. I hadn't realised there were quite so many. The next one is, what's the recommended approach when the relationship is completely broken down? And they've mentioned, so mediation would usually be the appropriate starting point, but both parties would need to agree with that, and you would need to demonstrate that. If that hasn't worked, you'd then look at whether there could be some redeployment or anything else. If actually then the relationship is broken down, that could be a lawful reason to bring their employment to an end. So it is some other substantial reason, but it's very much got to be the last resort. So you will absolutely need to have demonstrated that you have done everything you can to rebuild those relationships.
I certainly think there's a question about potential for without prejudice dialogue. Certainly that's something to consider, and from the perspective of if that individual is so unhappy in the workplace now, then would they prefer as an alternative a sort of a managed exit? So I think it's something to raise at that point if working relationships have soured so much.
Yeah, I think that's right. And, you can always have those without prejudice conversations if someone's clearly unhappy in the organisation. And that could be the person who's raised the grievance, particularly if they're not satisfied with the outcome. That is often what happens, that you lead to a protected conversation. We've probably answered this. Some of these are repetitive. How much information do you put in a grievance report for the person that raised the grievance? If the matter is to move to a disciplinary process following the investigation, assume that's not communicated. Yeah, that's interesting. Essentially, the grievance report is about whether the grievance is upheld or not, and then appropriate next steps. But that's likely to simply be, if it's a grievance about somebody else, that you will use, you will now invoke your employment procedures, and that will be the end of it. And that's quite often unsatisfactory to the person who's raised the complaint, because usually they want the person to be dismissed, or they want to know that they've had some disciplinary sanction. That's obviously confidential. So really, they are only entitled to know that the grievance has been upheld and that you are going to take appropriate action, and they're not entitled to know any more than that. I think we're nearly there. How do you balance disclosure of witness statements if they're a reluctant witness with GDPR obligations? Well, I think, you should not use witness statements unless individuals understand that they are going to be used for that context. So if you've got people who are refusing to be witnesses or refusing for their statements to be used, then you can't use them, and you just need to note that up. And then finally, Rich, do you have any thoughts on grievances against managers who are just managing an employee? And so often we see that with performance management, don't we? And the member of staff is aggrieved as a result. The organisation's got some problems where staff have never been managed, and a new manager attempts to do it, and it causes an issue. That is an age-old problem.
I think as we talked about earlier, it might be that it's something you can deal with entirely separately to the grievance. You could still, if depending how far that performance process has gone, but it equally, it depends, I guess, how much of an issue if there are any conduct issues relating to the manager. But if it's simply just raising an issue that's never been raised before, then I think it's legitimate to continue with that performance process and to pick up those issues as part of it. But potentially, yeah, separate grievance process to consider this.
And then the final question before we've reached our time, Justin, is around what about union reps? And so legally, where an individual is a witness, they don't have the right to go to a witness interview with their union rep or be accompanied at that meeting. But you do need to check your own policy to see whether that says anything about that. But actually, this is about trying to get people to engage. And so if they would be willing to attend, if their union rep was there, I would be pragmatic and I would enable that to happen. But obviously, you'll need to consider what's appropriate in the circumstances. And by doing that, can sometimes delay a process as well. So but generally, I think even if they aren't entitled, you might enable them to do that, particularly if you think they've got good grounds to be concerned, or if they need some support because they perhaps have Health or Equality Act issues. We've made it through all the questions, I think. So thanks so much for those. It's always the interesting part, and great to see you all this morning. And if you have any further follow-up or discuss any particular cases, please do contact Rich or myself or your usual member of the employment team.